Very good morning, honorable judges, and very good morning to all the participants, all the national schools in South Africa who are participating in this 12th edition of the National Schools Moot Court Competition. Very warm welcome to the Honorable Deputy Minister of Justice and Constitutional Development, Mr. John Jeffrey. Very warm welcome to commissioners here present, in particular Commissioner Advocate Andre Gom, and all the invited dignitaries, and a very warm welcome to all the students who have been participating in the preliminary rounds of the Moot Court competition at the University of Pretoria Center for Human Rights. My name is Lloyd Kuvea. I'm the Assistant Director at the Center for Human Rights at the University of Pretoria. I'm going to be the program director for this morning. I want to congratulate the teams that have made it to the final, and we are looking forward to great deliberations and submissions from you before the honorable judges. To start off our proceedings, we are going to listen to the national anthem. After the national anthem, we'll have a recital of the preamble to the Constitution by Basetsana Lesimola. If we can now have the national anthem as we all rise. Thank you very much. Seated. I now call upon Basetsana Lesimola to lead us in the recital of the preamble. Basetsana.
As I begin. We, the people of South Africa, recognize the injustices of the past, honor those who suffered for justice and freedom in our land, respect those who have worked to build and develop our country, and believe that South Africa belongs to all who live in it. United in our diversity. We therefore, through our freely elected representatives, adopt this Constitution as the supreme law of the land. So as to heal the divisions of the past and establish a society based on democratic values, social justice and fundamental human rights. Lay the foundation for a democratic and open society in which government is based on the will of the people. And every citizen is equally protected by law. Improve the quality of life of all. Improve the quality of life of all citizens. And free the potential of each person. And build a united and democratic South Africa. Able to take its rightful place as a souvenir state in the family of nations. May God protect our people. Nkosi sikeleli Afrika. Morena boloka setjhaba sa heso. God sootsen Africa. God bless South Africa. Muzimu fatuchetsa Afrika. Hosi katikesa Afrika. I thank you.
Thank you so much, Basetsana, for leading us in the recital of the preamble. So to the honorable judges, the timekeeping, at the back there you will see someone who will be assisting with timekeeping as the proceedings, when the proceedings start. Now we are going into the introduction of the panel of judges and the teams that are going to be making submissions before you, honorable judges. I'll now call upon Rola to assist us with those introductions. Thank you very much. Over to you, Rola.
That are appearing before us today are, to this side, the applicant, consisting of 2 schools from 2 different provinces. To this side, the respondents, consisting of 2 schools from different provinces, and they will be making submissions before this honorable court on a very important matter. You may be seated.
Thank you very much, Rola. Without wasting time, again, just to say it's a privilege for me to be standing before you, honorable judges, and directing the program for today. A few years ago, I was clerking at this very court, so it's really a privilege to be back, but in a different capacity. For now, I would like to now call upon Advocate Andre Gom, who is a commissioner at the South Africa Human Rights Commission, to give us his welcome and opening address for 10 minutes. Advocate Andre Gom, the floor is yours.
Thank you very much, and good morning to Justice Matopu, Judge of the Constitutional Court, and Deputy Minister John Jeffrey, the Deputy Minister of Justice and Constitutional Development, to the judges of the High Court that has also joined the bench today, and also to Ms. Jackie Cassette, Advocate Misa, and Commissioner Sibanyone, who is also part of the bench this morning, as well as to Mr. Vusi Mkhize, who is also with us today, the CEO, Chief Executive Officer of the South African Human Rights Commission. Also to officials from the South African Human Rights Commission and the Department of Basic Education and the Department of Justice and Constitutional Development, who have worked very hard to make today possible. And most importantly, to all the participants, particularly the learners and the teachers who have assisted you. This week marks yet another milestone for the National Schools Moot Court program, a display of critical thinking, the beginning of lifelong learning and education on human rights by young people who are indeed the future of South Africa. The Moot Court program is one of the key projects of the Commission and the Departments of Justice and Basic Education to conscientize young people about the Constitution, human rights, and the importance of the law in protecting themselves, their peers, and their communities. Further, this program forces young minds to ask pertinent questions about human rights, point to shortcomings in the law, and instills in them the values of equality, human dignity, freedom, and human rights generally in their daily lives. The Moot Court program is very close to my heart and that of Deputy Minister Jeffrey. Every year we are involved in also formulating the Moot Court question that you're debating today. But I'm also sure it's very close to the heart of all participants, including those who have availed themselves today to be on the bench. I attended the provincial rounds in the Western Cape, for example, and the judges there, mostly from Legal Aid South Africa, told me that this competition is the highlight of their year. Over the years, the program had rightfully focused on constitutional and human rights education. However, in recent years, the shift has been to sow a seed of confronting injustices and challenging human rights abuses at the scholar level, at the school level. This year's problem statement afforded the participants the opportunity to see themselves through the eyes of learners who have had their environment polluted and their water contaminated. Equally, the learners saw themselves through a business, a mine in this case, that prioritized profits and the creation of employment opportunities. The hypothetical problem is a representation of the daily struggles and challenges of South Africans, where economic and environmental considerations have to be weighed up carefully against each other. Put differently, the problem statement was not an easy one this year, irrespective of whether you found yourself on the side of the applicant or that of the respondent. That said, I'm informed that the learners were at all times vibrant and eager to challenge and defend their sides, mindful of the provisions of the Constitution and with respect for each other and the judges. This is in keeping with the objectives of the Commission, Human Rights Commission, and the departments involved to conscientize and inform our young citizenry about the world of human rights and the importance thereof to them, their communities, and their rights and responsibilities towards the country. With these few words, I would really like to welcome all of you to the final round of the 2023 National Schools Moot Court program and to the beginning of many careers in law and human rights. May we all enjoy this day and undertake to live the preamble of the Constitution as we head back to our communities. Thank you very much and enjoy every moment here in the Constitutional Court. May the best team win. Thank you.
Thank you very much, Honorable Commissioner. So from 36 schools in the preliminary rounds competing, we now have the 4 schools that have made it to the final round. I just want to now hand over to the Honorable Deputy Minister of Justice and Constitutional Development, Mr. John Jeffrey, to also give us his address. Thank you so much, Honorable Deputy Minister, for your support all the time with the National Schools Moot Court competition. You have the floor to address us. 10 minutes. Thank you very much.
Thanks very much to the learners who are, I'm sure, are very anxious to begin your arguments. I think this is the last speech. But to the members of the panel, the members of the Judiciary and Human Rights Commission, and to the Commission, and a special welcome to the learners, their parents and educators who are joining us here today, and the officials who have been very involved with this competition. We're extremely proud of this competition and the high caliber of participants it produces each year. One cannot help but be impressed by the learners in the various teams, and it definitely bodes well for the future of the legal profession and our justice system in the years to come. The competition was established in 2011 to create a greater understanding of the Constitution and human rights in South African schools, and it has truly gone from strength to strength. The year 2023 marks the 12th edition of the competition, following a brief hiatus in 2020 due to the COVID-19 pandemic, which necessitated a virtual format in 2021. The physical program has resumed since last year. Learners are given an opportunity to explore various sections of the Bill of Rights and also to develop their own writing and oratory skills and talents. This year, the learners have had to study the case of Liz Moreri, a learner who lives with her family in an informal settlement, and Flames Mine, a mining company which mines lithium for commercial purposes and employs most people living in the informal settlement. Without giving too much away, as I'm sure we'll be hearing from the teams, we can see different human rights which come into play here. We have, amongst others, Section 24 of our Constitution, which says that everyone has the right to an environment that is not harmful to their health or well-being, and to have the environment protected for the benefit of present and future generations through reasonable legislative and other measures. There's also Section 27(1)(b), which states everyone has the right to access to sufficient food and water. And there is Section 22, which states that every citizen has the right to choose their trade, occupation, or profession freely, but that practice of such a trade, occupation, or profession may be regulated by law. These are but some of the very many different human rights which interplay in our lives every day. Whether it's the right to freedom of speech, the right to freedom of religion, belief, and opinion, the right to freedom of movement, or our socio-economic rights, such as the right to have access to adequate housing, the right to have access to healthcare services, or the right to education, we exercise our human rights every single day in many different ways, often without even being aware that we're doing so. When it comes to the environment in particular, to give you a real-life example, in September last year, a mine dam collapsed and caused flooding in the Charlesville and Itumeleng residential areas of Jagersfontein in the Free State. The collapse destroyed the homes and properties of over 300 residents. The South African Human Rights Commission visited the areas and raised concerns about mining, its related impact on human rights, and the need for greater parliamentary oversight in the extractive industries. The Commission's concerns were also set out in some of its earlier reports, such as a report titled "The Underlying Socio-Economic Challenges on Mining-Affected Communities in South Africa," that was from 2018, which was prepared following extensive national hearings. The Commission highlighted issues regarding the safety standards posed by unused and neglected mines to children and communities in their surrounds, and also how mining extends to and affects a number of related human rights, including the provision of alternative housing, food, water, healthcare, access to schools, access to a safe and healthy environment, and other concerns of affected people. At the same time, one must be conscious of the fact that mining has a significant impact on our economy and leads to job creation. The revenue generated by mines and mining companies are taxed, and those taxes then go towards government being able to provide public services and build infrastructure. And if you look at the stats from Stats SA, it showed that mining dominated tax revenue in 2020 and 2021. In 2020 and 2021, mining accounted for 25% of total company tax. So this shows us how government, when we make different policies and laws, have to take a number of different and often competing and opposing factors into account. We have to consider different and often competing human rights, what the ambits of those rights are, and how and to what extent those rights can be limited. For example, some of you have heard of the Prevention and Combating of Hate Crimes and Hate Speech Bill, which is currently before Parliament's National Council of Provinces. In this bill, we had to consider the right to human dignity and the right to freedom of expression, taking into account that the right to freedom of expression does not extend to incitement of imminent violence or to advocacy of hatred that's based on race, ethnicity, gender, or religion, and that constitutes incitement to cause harm. We have to take all these aspects into consideration, and if we make laws or policies which then may impede or infringe on people's constitutional and human rights, our courts have the power to declare those laws unconstitutional and order Parliament to fix them. We currently have a number of bills before Parliament where the Constitutional Court has ordered that a certain law be changed or remedied with a particular deadline as set by the court. So our human rights affect everything we do as individuals and as a nation. And that is why it's so important for learners in all our schools to know their constitutional rights, and why we think that human rights awareness is so necessary. And this is one of the major goals of the National Schools Moot Court competition, and it's a competition which has gone from strength to strength. We believe that even more learners should be encouraged to participate in the competition, and we are hopeful that next year even more schools will participate in the essay writing stage and thus have the opportunity to be here as you are today. I also want to appeal to law firms and legal practitioners to help mentor some of the teams where possible. With schools being viewed as catalysts for social change, this program becomes relevant in instilling and educating young people, and thus also broader society, on constitutional values, human rights, and active citizenry. The National Schools Moot is a combination between a number of role players from the University of Pretoria, the South African Human Rights Commission, and the Departments of Basic Education and Justice and Constitutional Development. From the side of government, we want to thank everyone who's made this year's event possible. I want to extend a special word of thanks to the Chief Justice, the various judges and magistrates, legal practitioners, members of academia, and other stakeholders for their time and their unwavering support for the competition over the years. To all learners who participated, congratulations on what you have already achieved in this competition. You and your schools can feel very proud of what you've achieved. So without any further ado, I want to wish the finalists all the very best of luck, and we look forward to hearing your arguments. Thank you.
Thank you very much, Honorable Deputy Minister, for your insightful address and also for highlighting the significance of the National Schools Moot Court competition. It's now a privilege for me to hand over to the Chief Justice of this matter, Justice Matopo, so that we can start the proceedings for about an hour. Over to you, Justice Matopo. Thank you very much.
Good morning, everyone. Thank you for coming. We're just about to commence our proceedings. Let's have some few housekeeping rules. The participants, you will have 5 minutes of protection time. In other words, you will not be interrupted during the presentation of the first 5 minutes. The purpose thereof is to get you to warm up, to marshal your thoughts, and be able, during that short period of time, to convey to the bench what your argument or arguments are. Thereafter, you may be interrupted by questions from the bench. Please do not feel intimidated. The purpose of the questions normally is to enable you to clarify your argument, and in the process you will be able to persuade or convince the court about the force or the strength of your argument. And what normally happens in practice is, when there are questions from the bench, it is an opportunity for you as counsel to explain to the bench so that they can fully appreciate and understand your argument. The questions are not intended from the bench to trick you today and even in ordinary general practice. It's for the court to clear its mind. Because if the court does not ask you questions, you may end up not knowing and understanding what the court thinks. So make sure that when you do your presentation, you leave something in the minds of the bench. If you do not understand the question, feel free to ask the judge to rephrase the question, repeat the question. I wish you well. I guess now it's an opportune moment. You can call the case so that we can start. When you address us, there is a mic, you stand right there in the middle, and then you must press that gadget, and if it is red, it means you are now audible, and once, if there is a question from the bench, you switch it off. When you only switch it on when you're speaking. Do we follow, all of us? Good luck.
All right. In the matter between Liz Moreni and Flames Mine, this court is now in session and will be hearing submissions from the applicant and from the respondent. Members of the observers are required to put their phones in silent and to cease the court with silence. The applicants, ready when you are. We may be seated.
May it please the court. My name is Amukela Mohono, and I appear together with my co-counsel, L.E. Sikaulelo, on behalf of the applicant. I will be taking 7 minutes of the court's time, and my co-counsel will be taking 10. For justice, we will reserve 3 minutes for rebuttals. I will speak about the liability that we impose on the mine, and my co-counsel will speak about the sections of the Constitution that the mine has violated. Would your justices like a brief summary of the facts before I continue?
Yes, you may proceed the way you've prepared your argument.
Your justices, in this case, we find that there is a mine and that there is an informal settlement nearby. This mine has polluted the land, soil, and water of this specific settlement. And now the people are getting sick. Your justices, with that, I will move on to my first submission. Your justice, we submit the law of damages, and the law of damages has 4 elements in it. First is legal causation, negligence, wrongfulness, and lastly, there's duty of care. Your justice, moving on to the first submission, which is legal causation, we find that in this, there's a test called the but-for test. This test was established in the case of International Shipping versus Bentley that was heard in 1989 in the Supreme Court. Now, Your Justice, in this case, the question is, would the harm still exist if that specific actor that is being accused did not exist? Now, Your Justice, we will answer this question in 3 parts. First is the factual inquiry, then the causal link, and then we will question reasonableness. Your Justice, in terms of factual inquiry, the question asked is the wrongful act the reason for the damage? And in this case, Your Justice, we submit that it is. We submit that the mine ignored the fact that its smoke harms the environment and continued to operate, therefore harming the people. The people have now become sick, and therefore it is the wrongful act that is the reason for the damage. Secondly, Your Justice, we come to the causal link that asks, is there a link between what the mine is doing and the pollution? Your Justice, in this case, there is indeed a link, Your Justice. because the mine mines lithium for commercial purposes, and ingesting lithium results in a person getting stomach aches and runny tummies. These are consistent with the sicknesses with the symptoms that we have seen in the people. The people are sick and they have runny tummies and stomach aches, and this is in link with what the mine is doing. Justice, with that we have established a causal link between the mine and the people. We then come to the question of reasonableness. With this, Your Justice, we call upon the case of Samson versus Legal Aid that was heard in 2021, and in this case, a wrongfulness test was established. The wrongfulness test says that 3 conditions must be satisfied in order for someone to be said to be wrong. Your Justice, the first condition is that the harm must have been reasonably foreseeable. The second condition is that there must be a relationship of proximity between the actor and the victim. And thirdly, it must be fair, just, and reasonable to impose liability on this specific person. Now, Your Justice, it was reasonably foreseeable that the mine would cause harm to the environment. And we know this because each and every year the mine conducts an environmental impact assessment where it assesses its impact on the environment. In doing that, they could also know that the smoke will harm the environment and will harm the people, and yet they continued to operate, and in doing so harming the people. Your Justice, that proves that it was reasonably foreseeable. Secondly, there is a relationship of proximity between the mine and the people, because the people live only 5 kilometers away from the mine. Thirdly, Your Justices, we find that it is fair, just, and reasonable to impose liability on the mine as they are the direct cause of the harm that has been caused to the people. Your Justice, with that, we have satisfied the first question, which is of legal causation, and we then move on to our second submission, which is of negligence. Your Justice, the question for negligence is, would a reasonable person have acted the same way in the same position? And this test was established in the case of Kruger versus Goodyear that was heard in 1966. Your Justice, a reasonable person cares about the next person. And in this specific case, the mine did not care about the people. So a reasonable person, once having realized that they will harm the people in their actions, would have stopped and ceased operations. But that did not happen. And because the mine took less care than the reasonable person would, the mine is therefore negligent, Your Justice. Your Justice, with that, we move on to our third submission, which is of wrongfulness. Now, excuse me, Your Justices. Your Justice, wrongfulness is objective. And what we call objective is something that is seen through the eye of the collective community. Meaning that if the community believes that something is wrong and the mine still does it, or any person does it, it is then wrong. In this case, the society or the community believes that it is wrong to poison them and to place them in an environment that harms their health. And because of that, Your Justices, it is then wrong and the mine's actions were wrongful. This test and this question was established in the case of Matalane versus Ikamva Science that was heard in the High Court in 2010. With that, Your Justice, we then move on to our fourth and final submission, or my fourth and final submission. Your Justice, every single person has a legally imposed duty of care upon them. It's an obligation to care for the next person. And in this specific obligation was established in the case of Samson versus Legal Aid that was heard in the High Court, in paragraph 12, in fact, of the case. It is stated that every person has a legal obligation to care for the next person. Now, Your Justice, in this specific case, the mine did not care about the people. The mine continued to operate and harm the people, knowing fully well that its actions would harm. Now, Your Justice, because the mine did not satisfy its duty of care or did not fulfill it, the mine is then wrong. Your Justice, with these 4 elements that are in the law of damages, I have proven to you, Your Justice, that the mine is liable for the damage that it has done to the people. And therefore, the mine should be held in liability. If there are any questions, Your Justice.
Counsel, thank you very much for a very good exposition, I think, of the common law and of delict. There's something that's troubling me, and that is the fact, Counsel, that there's a lot of legislation which governs the whole question of environmental protection, which places duties on both the state and those who are conducting activities. Now, what role does the state play in this? And didn't they have obligations to make sure that the law's being abided? And if so, should you not perhaps have brought your case against the state instead of the mine?
Your Justice, the state is obligated to ensure that the mine complies with these. And in fact, it is in the, excuse me, Your Justice. It is in the Mineral and Petroleum Resources Development Act that the state has established that the mine remains responsible for any environmental liability. In this, we see that the state cares about the environment and will hold the mine responsible. Your Justice, it is the state's obligation to ensure that the mine is compliant, and the mine has assured the community that it is compliant with these. But because of the harm that is done to the people, evidence is given that it is not. So, Your Justice, the state has a duty to ensure that the mine does, but the mine can also lie.
Thank you, Counsel. So I understand your answer to be that they, in terms of the Act, the mine retains a duty and a responsibility for any damage it causes.
Please explain what you mean by retains,
No,
Your Justice.
I think I'm just trying to summarize your argument. Thank you. You've given me an adequate answer. Thank you.
Thank you, Your Justice.
Thank you, Mr. Mahomi. Do I understand that you are saying that the fact that the harm exists means that the mine is not complying with their obligations in terms of the Act? Or are you saying that the Act's obligations are not enough to prevent the harm that it needs to prevent?
Please rephrase your question, Your Justice.
Okay, it's really two questions. It's an either or. Are you saying because there is harm, it means that the mine is not complying with its obligations? Or are you saying that the obligations that they are complying with are not enough to prevent the harm?
Your Justice, I will answer both. The first question, which is whether because the harm exists, the mine is not compliant, we say yes to that. Because if the mine is harming the environment and they still claim to comply with the legislative requirements, then obviously that they're not complying with it enough and have not taken enough measures to ensure that they're not harming the environment. Secondly, Your Justice, please repeat the second question.
It's fine, you've answered my question. Thank you.
Thank you, Your Justice.
Mr. Mahono, does the fact that annually or every year the mine does its environmental assessment examination not good enough for the mine to escape any form of liability from the residents? If putting it differently, if the argument for the mine is that responding to your reasonableness argument, that what we did as a mine was reasonably necessary because every year we have an environmental impact assessment and the community is advised about what the results of that impact assessment. The purpose thereon being to minimize, reduce, or eliminate any harmful effects. And they say, that being the case, it is wrong of the applicants to suggest that we do not care, and it is wrong of the applicants to suggest that we did not, or we checked our obligation or responsibilities, and they submit the necessary reports that indicates that we did everything that was necessary. What would your response be?
Your Justice, at the end of the day, the people still live in a toxic environment. The people are still sick and their rights are violated. So if the mine claims that we checked and we know that we are harming them, and because of that we cannot take liability, we will not accept that, Your Justice, because they are still harming the people and the people need to be protected. Your Justice, we submit Section 11, which says that everyone has a right to life. This mine is endangering the people's right to life by harming them in this manner. The right to life, according to page 18 of the Constitution, which is the table of non-derogable rights, it says that the right to life is entirely protected, meaning that it should be upheld at all times. In this case, the mine threatens that right. So whether it knew, whether it checked, or whether it claims that it took reasonable measures, the right to life is still in danger, and it should therefore be protected, and we still hold it liable, Your Justice.
Thank you.
Thank you, Chief Justice. Counsel, mine is an easy one. It's a question of chicken and an egg. You quoted the decision in Samson.
Yes, Your
My
Justice.
angle is on foreseeability, right? And then when the Flames Man started operations, there were no people around there. People only came in, and gradually they were increasing the informal settlement. Now, my specific question is, has the mine violated any legislation because it was every year doing environmental assessment? What is your submission? What wrong? Where did the mine go wrong?
Your Justice, I will answer your question in two parts. The second part is that the people eventually did come to live there. In the same year, in fact, they're stated in the facts that in 2008, the Fontaine people did come to live there, which means that the next year, 2009, when the mine did its environmental impact assessment, people were still there, and they saw the harm they did and still continued to operate. That is only the first part. The second part, Your Justice, is that Section 24, subsection B provides that everyone has the right to have the environment protected for the benefit of present and future generations. In a situation, or at the time, in 2008, where the mine started operating, they did the environmental impact assessment and knew the harm. Even though the people weren't there, future generations could still live there, and future generations' right to an environment that is not harmful was then violated by the mine's continued existence.
So, Counsel, is your submission that the mine should immediately stop its operations?
Exactly that, Your Justice. We pray.
Thank you. Counsel, you've indicated that you did not see it necessary, from my understanding of the arguments that you presented, to join the state in this particular proceedings. As has been indicated by my learned colleagues, that this particular environmental impact assessment report is submitted to the Department of Environmental Affairs, as well as to the Department of Water Affairs and other stakeholders. So my question to you, Counsel, is should you have not joined the state in this particular proceedings?
Your Justice, what do you mean by joined?
Okay, should you not have also instituted this legal action against those departments that have issued or to whom these reports, the environmental impact assessment reports, were submitted?
Your Justice, while the state could have stopped it, the main actor is the mine. And the mine is the actor in this specific case that is harming the environment. The mine is what is causing harm to the people. And the mine has defied its obligations to protect the environment. And that is who we hold liable.
Thank you, Counsel.
Thank you, Justice Matopo. Your surname is Mahono.
Mohono, Your
Mohono.
Justice. Yes.
Mr. Mohono, must the mine stop what it's doing, or can it buy its way out of trouble?
It must stop, Your Justice.
Baba Mohona, Ninjani.
I'm good, sir.
All right. My question rotates around what you've just said. What about the other rights that are implicated? For instance, the right to food, security, health, the right to be able to be employed. What about those rights?
Your Justice, those rights will be addressed by my co-counsel. However, in terms of the right to be employed, which is outlined in section 22, I will then refer you, Your Justice, to page 18 of the Constitution that says that there are rights that are non-derogable. What this means is that there are rights that are entirely protected and cannot be limited. The right to life is such a right. And we uphold this, Your Justice. We find that this right is more important than the right to be employed. We would rather have a community that is unemployed than have one that is dead with job opportunities. And even logically speaking, Your Justice, if the people continue to be harmed and die, then who is the man going to give jobs to?
But we don't have a hierarchy of rights.
Your Justice?
We don't have a hierarchy of rights. You don't have a right that is more important than other rights.
But we do have rights that are entirely protected and cannot be limited, Your Justice.
All right, thank you.
Thank you, Mr. Mohono. If we look at the table of non-derogable rights, you also see that human dignity is entirely protected. And is employment not part of human dignity?
While it is, Your Justice, living in a safe environment is also a part of human dignity. And that is what we protect, Your Justice. With that, I hand over to my co-counsels, Your Justice.
Thank you, Mr. Mahon.
Justices, standing before you is Advocate L.E. Sikaulelo, as I was already introduced by my co-counsel. I will be submitting to this honorable court 4 main submissions. The first submission
Mr.
is...
Sikaulelo, can you just spell your name for the record, please?
Can I please?
Spell your name for the record.
Okay, it's S-E... K-H-A-A-O-L-E-L-O.
Sikaulelo.
Yes, sir.
Thank
Is your
you.
justice. Justices, if it pleases the court, I would like to proceed with my submittings. Justices, to this honorable court, I will be making 4 main submissions, which is that we must uphold the supremacy of the Constitution. The second submission will be that Section 24 of the environment is being violated by flame mines. The third submission is that Section 27, subsection 1, paragraph B, is being violated by the actions of flame mines. And my fourth and last submission, I will be submitting that Section 29 is being violated by flame mines. My first submission is that I highlight the supremacy of the Constitution. Section 2 of the Constitution states that the Constitution is the supreme law of the Republic. Law or conduct which is inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. We see flame mines violating rights which are in the Constitution, and therefore we can deem that the actions are invalid. I'll be moving on to the preamble. It states that anyone residing in the public is obliged to adopt the Constitution as the supreme law of the Republic, and this is the rule of law. In a matter S versus Makwanyani, held in 1995 in the Constitutional Court, paragraph 7 affirms that the Constitution is the supreme law and must be taken into consideration at all times. Moving on to my second main submission, which is that flame mines is in violation of Section 24 of the Constitution. Justices, Section 24 states that everyone has the right to an environment that is not harmful to their health or their well-being. And they have the right to have their environment protected for the benefit of present and future generations through reasonable legislative and other measures that firstly prevent pollution and ecological degradation, secondly promote conservation, and thirdly secure ecologically sustainable development and use of natural resources whilst promoting economic and social development. Justices, we see this section being violated by flame mines as they are not mitigating or preventing the pollution happening in the area. the Einfontein residents have filed a complaint to the CEO regarding the complaints about the pollution that they have in the environment, and the CEO has not given attention to those complaints or has not given them an ear when filing those complaints. Justices, in terms of Section 36, rights in the Constitution can be limited, but in this case, if Section 24 is limited, other rights such as Section 11, which is the right to life, Section 10, which is the right to dignity, and Section 9, which is the right to human equality, can be infringed. Justices, moving on to my third main submission, which is that flame mines actions are in violation of Section 27, subsection 1, paragraph B. Section 27, subsection 1, paragraph B states that everyone has the right to have access to food and water. Now, we must take into consideration that in order for the Einfontein residents to have food, they do subsistence farming, which means they farm on the land for their own food or they plant their own food. If the land is polluted and the food is deemed inedible, what about their access to food? Now moving on to the violation of their right to have access to water. The Tiger River is the main water source of the Einfontein community. If it is polluted and contaminated with lithium and the water is not healthy enough for human consumption, this means that flame mines is in violation of Section 27, subsection 1, paragraph B of the Constitution. The matter Gauteng River Concerned Residents versus Gauteng Local Municipality held at the Mahikeng High Court in 2023. At paragraph 5, it states that the right to potable water is a basic human right, and we cannot have basic human rights being infringed in order to support the mine in its main provisions to the people of the community, which are the right to work and the right to have the allocations of these bursaries. The right to potable water must be upheld at all costs because food is a fundamental need of a human. In the matter, Harmony Gold Company Limited versus Regional Director, Free State Department of Water Affairs, and others. At paragraph 21, it states that persons who have an obligation to prevent water pollution extends to former landholders, persons who had the right to use the land at the time of actual or potential pollution, and any person who had negligently failed to prevent potential or actual pollution. Flame Mine hasn't put reasonable measures in place to prevent the Tiger River water from being polluted, thus polluting the main water source of the Einfontein residents, which limits the right of the resident to have access and sufficient food and water. Justices, the Water Service Act 108 and National Water Act 39 of 1998, at section 19, states that an owner of land, a person in control of land, or any person who occupies or uses the land on which A, any activity or process is or was performed or undertaken, or any other situation exists which has caused, or is likely to cause pollution of a water source, must take all reasonable measures to prevent any such pollution from occurring, continuing, or recurring. We can see that flame mines have reasonably foreseen the damage that they cause to the Einfontein community, but they still haven't taken reasonable measures to make sure that this is mitigated. Justices, I will be moving on to my fourth, last and main submission, which is that flame mines is in violation of Section 29 of the Constitution. Justices, Section 29, subsection 1, paragraph A, states that everyone has the right to a basic education, including adult basic education. In this case, we see the dear Bolenas succumbing to the ill health caused by ingesting and inhaling the lithium that is omitted by the mines. Justices, when Elena is sick, the Elena cannot go to school, thus making them miss days, if not weeks, of schoolwork, and thus hindering them access to Section 29, subsection 1, paragraph A, which states that they have to get basic education. If they have ill health, they cannot attain this basic education on a day-to-day basis. The above given can be supported by international law. Article 3 on the Convention of the Rights of the Child states that in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interest of the child shall be a primary concern. In this case, the best interest of the child is to get basic education. The best interest of the child is to live in an environment that is healthy, and the interest of the child is to get sufficient water and food that does not harm their health. Justices, if we gauge what weighs more between the adult's interest and the children's interest, we can establish that it is always the child's best interest that overweighs the adult's interest. Justices, if it pleases the court, I would now like to move on to my prayers. As lawyers for the applicants, we pray that Flame Mines activities are held. We pray that this honorable court rules that Flame Mines activities are in violation of Section 24, Section 27, subsection 1, paragraph B and Section 29 of the Constitution, and must therefore be deemed unconstitutional. We also pray that Flame Mine is held liable for the ill health of the Diabolinus and the Einfontein residents and must cease operations. And we would like the court to submit that the court grant us costs in our favor. If there are no more further questions from the justices, I would like to take my seat.
Mr. Sikaulelo. My question is directed at the grounds of your claim, your section 24, 27, and 21 rights. Are those rights not enforceable against the government? The mine will say, I'm just there as a mine to mine and help the community to get employment and everything that needs to be done. And if the mine council for the mine were to say, this is not our responsibility, whatever that we have to submit, we have submitted in terms of the environmental impact assessments, what would you say to that submission?
Justices, the government has played their part, the government or the state has played their part by issuing out the EIA so that the flame mines can be complied within it. But the flame mines, as my co-counsel has already said, we need to establish reasonableness. The mine must take reasonable measures to make sure that the sections aren't violated and the mines are complied within the EIA. We have seen the CEO receiving a memorandum of complaints, but he did not want to read the complaints because Liz Mureri and her friends, he cited that they are only children. So in this instance, we say the government have played their part and it's now time for the flame mines to play their part too.
Thank you, Counsel. I would like you to explain to me what I'm considering is, are you not elevating the right to a healthy environment or to an environment that is not harmful to health? Are you not elevating that right to the right of life? Because even if you are a hungry child, you say a child that are ill, can't go to school, can't participate properly. But a child who is hungry because his parents is unemployed and can't feed him also cannot progress at school. So that is the question I have, is whether we are really dealing with the right to life.
Justices, this is where we as applicants would like the government to come into play. We would like the government to provide food parcels or grants to the kids which the parents cannot work or cannot be able to provide for them. But as soon as we see flame mines violating Section 11 of the Constitution, we say they must cease operations. Rather have children living a bare minimum life where they get food rather than the parents being employed and the kids being sick and not being able to attend school on a day-to-day basis.
Counsel, thank you. You've relied directly on some of the rights in the Constitution, and the one that you've spoken to is the right to water, Section 27(1). That right is, that section is just one component of a broader right, Section 27(2). 2, which talks about the state's responsibility to progressively roll out that right in accordance with its resources. So if you read those two parts of the rights together, can you just say, well, we've got a right to water? Is it not a bit more complicated than that? What, would the state not say to you, well, we are reasonably progressing the right? And then anchored with that is the same question, is it not the responsibility of the state to ensure that there is clean water as opposed to the mine?
Justices, the state perceive the mine as a mine that can be reasonable. They have issued a EIA that my flame mines must be compliant with. But if we see the EIA not being compliant with it, whilst the state have already played their part, it means the state must be omitted and we must only focus on the flame mines, which is not taking any reasonable measures to prevent the violation of Section 27, subsection, or Section 27 as a whole.
Can I ask you just to speak a little bit, please, Council, to the first part of my question, which was saying you need to read Section 27 as a whole. So the first part plus the second part, which talks about reasonable implementation.
Justices, Section 27, subsection 2, which we keep enunciating, states that the state must take reasonable legislative and other measures within its available resources to achieve progressive realization of each of these rights. And we say the reasonable legislative that was taken by the government was telling the flame mines to be compliant within the EIA. And that is what the government have in its resources. But flame mines have the resources and the capability to take reasonable measures to make sure that the ecology isn't degraded and the environment remains healthy.
Right, Council. I am a bit worried by your all or nothing attitude. I want you to address me specifically in relation to the matter of Fuel Retailers Association of South Africa versus Director General Environmental Management. Especially, let's look at paragraph 45. I wish to quote for you. I quote, open quote, it envisages that environmental consideration will be balanced with socio-economic consideration through the ideal of sustainable development. This is apparent from section 24B, Roman figure 3, which provides that the environment will be protected by securing ecologically sustainable development and use of natural resources while, very important, promoting justifiable economic and social development, close quote.
Your Justice, the very same paragraph that you just quoted in it has that the environment must be kept sustainable, meaning that if flame mine keep polluting the land, it won't be sustainable. Future generations won't be able to use it. Does that answer your question?
But it doesn't close the mine. It says you can have both. You don't have to have an either-or situation.
And it also states that the social and economic developments must be justifiable. In this instance, they are not justifiable. We are not going to uphold the right to have a better social life than a better environmental life.
Council.
Mr. Sekaulela, which is more important, health or employment?
We consider health to be more important. We consider health to be more important because an unhealthy person cannot simply work.
Thank you.
Council, the issue that you raised about your concern of the learners not being able to access schools because of the ill health associated with the environment and the food that they're eating is unhealthy, etc. have you approached the Department of Basic Education to assist you in this regard? Were there any complaints lodged on behalf of the learners to the mines? Was it brought to the attention of the respondents?
Yes, ma'am, it was brought to the attention by Liz Moreri and her classmates, but the CEO denied to meet them or read their memorandum of complaints, citing that they are only children and they cannot make any demands on the mine. And take into consideration that Liz Moreri had even though she is a minor, she had oral consent from the SGB and the school's principal to go there and act in the best interest of a class or a group of persons, which are the I-14 residents and the Diebo learners.
Thank you.
Thank you, Mr. Skaulet. Would that be the other?
Pardon?
Would that be the applicant's case?
That would be the conclusion of the applicant's case.
And you're asking for an order in terms of your notice of motion?
Pardon?
One, you're asking for an order, that we make an order stating that the mine violated section 24, 27, 29 of the Constitution and it will be held liable, and also they must pay your costs.
Yes, Your Justice.
Thank you.
Thank you.
The respondents? I mean the mine. Council, you've had the debate between the bench and your colleagues for the applicant. Thank you. Place yourself on record.
Your Honorable Justices, we confirm our appearance on behalf of the respondents. I am Iminkosiane. It's spelled I-M.
Just hold on, be slowly. I
am I, and then my surname is N-K-O-S-I-Y-A-N-E.
Kosiane.
Yes, Your Justice.
Thank you.
I am going to be addressing the first issue in dispute for 12 minutes. My co-counsel, Ms. Siloana, is going to be dealing with the second issue in dispute for 8 minutes. If it pleases the court, before I get into my argumentation, I'd like to engage on what the counsel for the applicants contend. The first counsel contends on factual inquirement. Now, the responses we have to this, Your Honorable Justice, is one, the tests that they conducted on their side were unreliable, and they do not justify their argument, as they actually did not establish or even touch on when we actually deem something to be a causal issue. Your Honorable Justices, their submissions were basically based on assumptions that the mine pollutes, then causes the ill health of the people, without taking into consideration other external factors which could have led to that. And that is what I am going to be dealing with in my case. My co-counsel, Ms. Silwana, will further engage on their submission on air quality and their interpretation of the Sampson versus Legal Aid case. Your Honorable Justices, there are two main integral facts which we would like to outline before this honorable court. One, as per paragraph 6 of the case file, it is stated that each year, Flames Mine commissions an environmental impact assessment, which I will herein be referring to as the EIA, to ensure that it complies with all the relevant and applicable legislation, such as the National Environmental Management Act. And the results of this assessment were up to date and effective. The second thing is that according to paragraph 5 of the case file, it is stated that Flames Mine offers most residents work in the mine, and it also offers bursaries and scholarships to the Yebo learners who want to pursue a degree that is relevant to the mining sector. The mine in this particular instance is an essential source of income for that community and to actually uplift their standard of living. My submissions are going to be under the constitutionality of Flames Mines activities. We submit that according to Section 24, there are provisions for the protection of the environment and to secure ecologically sustainable development while promoting justifiable socio-economic development. We argue, Your Honourable Justices, that Flames Mines activities are not in breach of this section as contended by counsel for the appellants on the basis that each year Flames Mine does commission an EIA that proves that it complies with all the relevant and applicable legislation in this particular instance, and the mine has always exercised its duty of care and its compliance reports are up to date. Moreover, Your Honourable Justices, we submit that in the case of Fuel Retailers Association of Southern Africa, at paragraph 44, it was held that what is immediately apparent from Section 24, subsection A is the explicit recognition of an obligation to promote justifiable socio-economic development. It was further held that economic and social development is essential to the well-being of human beings. Now, Your Honourable Justices, this case law is binding as it was heard before this Honourable Court, and this case is relevant to this particular case as it concerned environmental law and the principle of an intergenerational justice, which is what we are going to be basing our arguments on. Your Honourable Justices, we argue that economic development means social development in this instance, and it actually means to uplift the standard of living of the people in Ainfontein. If the mine ceases operations, Your Honourable Justices, the economy of that particular area will not be improved, and their standard of living will not be improved, as the facts do also outline that Ainfontein sprang up when the mine started its operations. Moreover, Honourable Justices, you should note that we are not merely silencing the appellants based off of the fact that they are given employment by this mine. However, it is imperative to actually consider that the mine understands its obligation to promote justifiable socio-economic development in the presence of the protection of the environment. And with taking into consideration that line of work, industrialization as a whole, pollution to the environment in some cases cannot reasonably be stopped or avoided as per the legislation that I'm heading to now. Your Honourable Justices, we submit that Section 28 of the National Environmental Act 107 of 1998 provides that pollution in some cases cannot reasonably be avoided or stopped, and it is then imperative to try and minimize the impact of that pollution. Your Honourable Justices, we argue that Flames Mine meets this criteria on the basis that it tries to minimize and mitigate its pollution through the EIA that it commissions each and every year. And the mine in this instance is engaging in sustainable development, and this means that it understands its obligation and practices its obligation of striking a balance between socio-economic development in the presence of the protection of the environment, and it has done evidently so through the EIA. Now, Your Honourable Justices, why is sustainable development something that is integral and something that you should take into consideration when interpreting and dissecting this case? We submit that in 2002, representatives from over 180 countries gathered in our country for the Johannesburg World Summit on Sustainable Development, where it was held that sustainable development is a world priority. Moreover, we submit that Principle 3 of the Rio Declaration provides that the right to development must be fulfilled so as to equitably meet the developmental and the environmental needs of present and future generations. Now, that is when an intergenerational justice actually takes place. We argue that in order to protect the environment in this instance, there should be sustainable development, and the two motives can and are coexisting within the activities of the mine. Your Honourable Justices, the mine in this instance does balance these socio-economic development in the protection of the present, of the protection of the environment, as per previously and justifiably submitted to this Honourable Court. Now, Your Honourable Justices, we submit that Section 27, subsection 1b of the Constitution provides that everyone has a right to have access to sufficient food and water. Now, we argue that an assumption that there is a core link between the activities of the mine and the fact that the water in the Tiger River has been seen to mysteriously turn greyish over the years ought to be declared as something that is invalid by this Honourable Court on the basis that there are many other external factors which could have led to the contamination of Tiger River. As according to to the submissions to the United Nations Special Rapporteur on adequate housing, what characterizes South African informal settlements is the issue of poor sanitation facilities. Now, this would then mean that there is lack of proper sewage systems and waste management infrastructure, which could directly lead the rivers within close proximity to turn grayish over the heads and potentially harming the people's health. Now, what this further exacerbates, the Honorable Justices, is the fact that it should not be the Flames Mine that is responding to these people's complaints. However, it should be the government, as according to the Housing Act 107 of 1997, national, provincial, and local government should help those most in need to get housing through housing development. Now, Your Honorable Justices, it is the government's responsibility to provide proper housing and proper plumbing for these people to actually make sure that their water is protected in this particular instance and is not prone to contaminations. However, the mine does understand its obligation to not pollute that water, and it tries to do so through the EIA that they commission each and every year. But even if, thus we have justifiably submitted to this court that the respondents are not liable for the violation of Section 24 and Section 27 of the Constitution. But even if the appellants still contend that these rights are violated, we would still justify it as a limitation. According to Section 36 of the Constitution, the rights in the Bill of Rights may be limited only in terms of law of general application to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom, taking into account all relevant factors which I will be arguing under. Number one, Your Honorable Justices, we submit that the previously submitted rights are not non-derogable rights. They are not absolute rights and therefore may be limited. And moreover, the importance of the purpose of the limitation of these rights was to actually promote justifiable socio-economic development in the presence of the protection of the environment and thus uplifting the standard of living of the people in Einfontein, as per previously submitted. And thirdly, the nature and extent of the limitation is also justifiable, as any mine cannot necessarily or reasonably stop pollution to the environment, and it is permissible through the Section 28 of the National Environmental Act, as per previously submitted to this honorable court. And the relationship between the limitation and its purpose is also linked and justified, as had the mine not limited these rights, the people in Einfontein would not be having employment, the children would not be receiving these bursaries. However, as per previously submitted, we still contend that even though the mine does give these people, it doesn't mean that it's silencing them. And it actually gives these people opportunities to voice out their concerns through the general meetings that they actually have each, that they commission in their practice. And therefore, the limitation of Section 24 of the Constitution would also be justified by my previously stated analysis. Now, Your Honorable Justices, my co-counsel will be further elaborating on the second matter, which is the ill health of Diabolenas in Einfontein informal settlement residents. And if it pleases the court or there are no other further clarifications, I would like to take my leave.
Mr. Gothiane, is your client prepared to make less profit so that the residents can be healthier?
Your Honorable Justice, as per previously submitted, in this particular case, it would not be fair to impose such liability on the respondent, as we have repeated, as we have previously submitted, that they are not liable for the ill health of these people, and so the mine should continue operating and should not have any of its operations tampered with, if it pleases the court.
Thank you.
So you've indicated and you've made emphasis on the fact that you submitted the environmental impact assessment, which you refer to as the EIA, to the department, and that is compliance. But wouldn't you think that apart from submitting such a report, and you've indicated further that there are external factors that may contribute to the pollution of the river, but don't you think as the mine itself that your obligation does not finish at the line where you submit this particular report to the department, that there should be other operations that you put in place to mitigate and ensure that the complaints of the residents are being addressed and not being dismissed because the applicants, your learned colleagues, have indicated or have averred that any complaints in the meetings, the community meetings that you do call upon, are dismissed by your CEO. And of particular concern to me is the right of the children to a good and healthy life. So what is, because you know, if they are not healthy, they cannot attend school, their learning then is affected. So my question to you is, what mitigation strategies what plans do you have in place to help to eradicate or to mitigate the pollution that is being, spoken about, not only of the river, but the air pollution and everything, in order to ensure that there is a sustainable environment in that particular community?
Your Honorable Justice, we submit before this Honorable Court that to firstly answer the question on if it was justifiable for the CEO to decline to meet up with the minor appellant. Your Honorable Justices, in law we have majors and minors. Now this would then mean that the CEO was reasonably justified to actually question the rationality of children coming to disrupt his or her busy schedule just to discuss these complaints. But even in such a case like that, Your Honorable Justice, to submit that there are rules and regulations and procedures that should actually be followed when such is to happen. Now, Your Honorable Justice, in this particular case, a CEO has a lot of responsibility to just meet up with kids to discuss these complaints. And moreover, the mine does afford the people the opportunity to actually voice out these complaints, and those opportunities are not intrinsically subjected to only majors, and we believe that minors can also be subject to actually voice out their concerns in that particular instance. Now, Your Honorable Justice, there is no absence of...
Sorry, I just want to ask you, are you saying that children don't have rights and interests, and that therefore the CEO, he silenced them, did he not?
Your Honorable Justice, he justifiably questioned their rationality by silencing them. However, Your Honorable Justice, you should note that in this particular instance, the CEO did not silence them, because the CEO, or rather Flames Mine, or rather the Flames Mine in essence, does actually give out opportunities to these people to voice out their concerns through the general meetings that they host with them. And in this particular instance, Your Honorable Justice, there is no absence of redress in due course. As Your Honorable Justice, if the appellants were really eager to actually talk about these complaints, they would have been afforded the opportunity to do so in the next general meeting. So in this particular instance,
Would
they are
that
considered.
not perhaps have been too late, Counsel? Shouldn't there have been some level of urgency here? People are getting sick. There was evidence presented to your CEO that, that the activities of the mine may be implicated.
Your Honorable Justice, still it does not justify the fact that this mine is the one that is causing the ill health of these people, as per previously submitted. Your Honorable Justice, we question the, in this particular instance, we question the tests that were conducted by these people, as they do not prove that this water is contaminated by lithium-related contaminants that are caused by the mine in this particular instance, as it is not stipulated in the facts, and we wouldn't want to base our submissions off of assumptions, but rather base our submissions of facts that are stipulated in the case file. However, Your Honorable Justice, it does justify us in the sense that it is not stated what precautionary equipment was given to these children while actually doing this experiment. And in that particular instance, Your Justice, this Honorable Court can preclude that those tests are unreliable and unjustified. And moreover, they do not have proper certification submitted to actually prove that this source, or rather these tests, were reliable. So in that instance, we are still justified as the respondents, Your Honorable Justice, if it pleases the Court.
Thank you, Counsel.
Counsel, you raised the issue of the conference that was held, I think it was in Sentin, the Sustainable Development Conference. In that conference, it was mooted that companies such as yours should take into account the biocentric approach that is now prevalent throughout the world, meaning the environment should be given certain rights. Now, what is your company doing to be in compliance with the dicta or the resolutions of the conference that you mentioned? Are they willing to go along with NEMA, especially Section 4, which talks about sustainable development, which requires that the disturbance of ecosystem and loss of biological diversity, I'm quoting, are avoided, or where they cannot be altogether avoided, are minimized and remedied? Are they willing to remedy the river?
Your Honorable Justices, as per previously submitted and justifiably submitted so to this Honorable Court, the EIA in this particular instance are enough reasonable measures to actually minimize the amount of, or rather the impact that this mine has on the environment. Your Honorable Justice, those provisions do not say that a mine should have perfect mitigation strategies, but rather reasonable mitigation strategies. And in this particular instance, the mine is directly engaging in that through sustainable development and understanding and practicing its obligation to balance socio-economic development in the presence of the protection of the environment. And we have justifiably submitted to this court how it does so. Yes, Chief Justice.
Mr. Nkosiyane, are you saying that the mine is doing what the Act requires it to do, and therefore it doesn't matter if it is still causing harm, because it's doing what the Act requires it to do?
Your Honorable Justice, it is our submission that the mine is permitted by law as per Section 28 of the National Environmental Act to pollute the environment to some extent. Your Honorable Justice, it is our submission that the Flames mine in this particular instance has actually won this case from the Mpumalanga High Court up until the Supreme Court of Appeal on the basis that they do commission this EIA and their compliance reports are up to date, which proves that they are in compliance with all the relevant and applicable legislation that is stipulated by the NEMA Act. And in this particular instance, yes, Your Honorable Justice, they would be justified.
Mr. Nkosiyane, can we look at the objective facts, the reality on the ground? We have the report by the mine to the effect that annually it does commission and prepare reports. And then we have the community on the ground that says, notwithstanding what the mine tells you as a court, we continue to suffer the ill effects as a result of the operations from the mine. The report that has been submitted is not borne out by the objective facts of the community which is suffering. Learners don't go to school. Parents are forced to retire early because of ill health. So the report that it's been championed, it's not the paper that is written on. It's not worth the paper that is written on. What would you say to that submission? And they say this, regardless of the fact that they succeeded in the High Court and in the SCA, they may have pulled a wool over the eyes of those justices or judges. But the reality is, we are suffering. The water is contaminated. The learners miss schools. And the report from the school and the teachers is that most of the learners are coughing, have running tummy, and their academic progress is being disrupted because they can't meaningfully attend school. Their right to education, their right to clean living water is being frustrated by the mine.
Your Honorable Justice, we have previously and justifiably submitted before this Honorable Court that if we take into consideration that we would be dissecting this case based off of assumptions, Your Honorable Justice. The appellants in this particular instance did not prove the causal link as per our rebuttals, and they did not actually attest or rather bring credible evidence as to how it is directly the mind that is leading to these people having this ill health. And we have justifiably submitted so how it is the government's obligation to try and prevent and protect those aspects. And it is only an obligation to the Flames mind to actually mitigate and lessen their pollution. So we would still be justified on those grounds, Your Justice, if it pleases the court.
Thank you, Counsel. I want to come to an issue of costs, and it relates to a question that some of my other colleagues asked. Even if we are with you, do you think that this litigation would have ensued if the CEO took the time to speak to the children? Because if he took the time to speak to the children and the whole situation could be diffused or discussed, this litigation, through all its processes, might have been unnecessary. So why should this court, even if it feels that it is with your client, not grant a cost order against you?
Honorable Justice, this court should not grant a cost order against the counsel for the respondents in this particular instance, as we have justifiably submitted that there is nothing that they are doing wrong. They are compliant with the law. And Your Honorable Justice, these people are the ones that are a main employer for those people. They are uplifting these people's standard of living. They are offering bursaries.
I want to jump into your soup here. I must say, I find it a little bit disconcerting that throughout your argument, you are referring to the community members who are working for the mine, without whom this mine cannot operate, as these people. I just want to put it to you.
Apologies, Your Justice. As the Flames mine, as the Ainfontein informal settlement residents are actually being uplifted by this mine is providing scholarships and bursaries to these people. And it actually takes into consideration also people who are not working in the mine. These settlement in the Ainfontein informal settlement residents who are not basically working in the mine. And it would then mean that it also benefits people who are not working in the mine indirectly in that particular instance, and they would still be justified, Your Honorable Justice, if it answers your question. Thank you, Justices.
I think you may have to return. There's a question for you. Sorry.
Thank you very much, Counsel. Counsel, I'm a bit perturbed by the approach, in that you constantly feel that if the mine complies with legislation, there is no need for them to do anything else. It's complied, it's submitted its EIA, and that's where its responsibility ends. You provide bursaries, etc. But you're not addressing the issue of the health of the very employees of that community, come from that community. The children of those families. So what is the corporate social responsibility of the mine? Do they have, in other words, do they have a strategy apart from just complying to the law? Are there other means by which they try to engage? Maybe you've indicated it's probably the informal settlement, and I know you referred, to the Department of Housing should be providing better housing. But shouldn't you have engaged a little bit more so that positive action can be taken together with you as the mine in order to resolve the dilemma that the community that serves your very mine, the employees come from that community to resolve this particular issue?
Your Honorable Justice, we have justifiably submitted to this court as to what characterizes an informal settlement, and we have justifiably actually made this court consider that what this further exacerbates is the fact that the government should be responding to the residents' complaints. And in that particular instance, Your Honorable Justice, the mine does actually have other measures that they do to actually try and engage with the community, and it is through the meetings that they actually have with the residents in this matter, as they actually discuss the complaints that they have and try to collectively find mitigation measures or other measures that could lessen that pollution. And in this instance, Your Honorable Justice, they are still justified. If it answers your question.
Thank you. I'm just concerned that, you know, it's about engaging with communities, but what about the other stakeholders that play a role in ensuring that there's a healthy environment for people of the informal settlement? What kind of engagements has the mining sector done with those communities? And that's the issue that I'm trying to ascertain, whether the mine has been engaging in a bigger picture in order to resolve this particular issue.
Your Honorable Justice, it is not speculated or stipulated in the facts if the mine did try other mitigation measures. So we would respectfully submit that to this honorable court and not come up with assumptions or lies, if it pleases the court. Thank you, Your Justice.
As it pleases the court, I'll be addressing the last issue, which pertains the causal link between the ill health of the infant and residents and the mine's operations. We, as counsels of the respondent, have critically evaluated the basis of the accusations. As it pleases the court, appearing on behalf of the respondents is Ms. Khokano Selwadi, as second earliest. S.
Can you spell your name? S?
As it pleases, yes. S.
S.
E.
E.
L.
L.
O.
O.
A.
A.
N. A.
Silwane.
Silwana.
Miss Silwane. Is it your name or your surname?
As it pleases, it's my surname, Your Justice.
Thank you, Ms. Silwane. You may proceed.
We, as counsels of the respondent, have critically evaluated the basis of the accusations made against the respondent. It is important to question the credibility of the tests conducted by the learners during their science exposition. While we respect their efforts, it is essential to ascertain the credibility, methodology, as well as the accuracy. Isolated test results must be scrutinized carefully, particularly when juxtaposed with Flames Mine's consistent compliant reports. The use of young, inexperienced learners to carry out these tests raises questions about the professional expertise and adherence to scientific protocol. My Justices, we cannot solely rely on the applicant's test without thorough verification and validation made by certified experts to establish a more direct causation between the alleged contamination and the operation of Flames Mine. We question the chain of custody in the sense that it was not stipulated in the facts of this case that the learners were given sanitary equipment to carry out these samples. The test conducted by the learners raises concerns about the professional expertise involved. Given the complexity of the chemicals present in the mine's operations, it is essential to scrutinize the methodology and qualifications of those conducting these tests. We must question the validity of the test results and consider possibilities of biases or error. However, it is crucial to remember that the Flames Mine has diligently complied with all the environmental regulations and has upheld its duty of care towards the community. Without a clear causal link between the mine's activities and the reported health concerns, it would be unjust to seize the mine's operations, consequently jeopardizing the socio-economic growth it fosters. Counsels for the respondent respectfully argue that there is lack of substantial evidence establishing a direct causal link between the health issues experienced by the Dwebo Secondary School learners and the mine's operations. The mere proximity of Dwebo Secondary School to the mine should not automatically be equated to health risks. Our learned friends, or rather the applicants, have mentioned the case of Sampson versus the Legal Aid of South Africa. However, their interpretation was incorrect. At paragraph 20, it was held, I quote, that the test for reasonable measure is that an applicant can establish wrongfulness only when he can prove three things. First, that the causing of damage was reasonably foreseeable. Secondly, that the relationship of proximity or neighborhood existed between the parties. Thirdly, that in all circumstances of the case, it was fair, just, and reasonable to impose liability on the respondent. The case above is relevant in this matter as the problems that were faced by the Dwebo Secondary School learners were not necessarily foreseeable by the respondent as they did not cause the contamination. Secondly, the relationship of neighborhood did not exist between the Eindfontein residents, between the Eindfontein community and Flames Mine, as Eindfontein is situated approximately 5 kilometers away from the mine. Thirdly, that it is unfair, unjust, and simply assume that the applicant's health concerns are related to the mining operations. These issues could have multiple underlying factors, such as inadequate sanitation or other external environmental factors. Your Justices, the CEO of the mine declined the meeting regarding this issue does not automatically equate to the dismissal of the concerns raised. CEOs have a merit of responsibility, and their inability to attend a specific meeting does not automatically equate to dismissing the issue. Proper channels for addressing this issue should have been followed by the applicants, and appropriate communication would have been established. We implore to this esteemed court to consider the facts presented. Flame Mine operates lawfully and in accordance with environmental regulations. Any claims of constitutional violations are unfounded, as there is no conclusive evidence linking the respondents' operations to the alleged contamination or health issues. We must strive for fairness and impartiality, ensuring that legitimate concerns are addressed while protecting the livelihood of the Eindfontein community. Counsels for the respondent further argue that they are not in violation of Section 29, as there is no causal link between the ill health of the Dwebo Secondary School learners to the mine's operations. However, the respondents are actively promoting Section 29 through their provisions of bursaries and internships. We respectfully plead this esteemed court to uphold the decisions of the lower court and reject the appeal of the Dwebo School governing body, thus reaffirming the constitutional legitimacy of Flames Mine, ruling in favor of Flames Mine and recognizing their constitutional rights to continue their operations. If it pleases the court, should I move on to my prayers, or are there any questions from justice? Counsels for the respondent request this honorable court to grant the following orders. Firstly, to declare the ruling in the High Court correct in finding the mine's activities justifiable, since they are clearly not in violation of Section 24, Section 27, subsection 1b, and 29 of the Constitution. Secondly, to declare that there is no causal link between the ill health of the Dwebo Secondary School learners and the Eindfontein residents, and therefore the mine continues operation. And lastly, the applicants should be subjected to all the costs of this suit and the cost of all the respondents' counsels.
All right, thank you.
Thank you, Ms. Silwana. I have two questions for you. The first is, when this issue about the test came to the attention of your client, did your client do anything to check an extra testing on its part or anything like that to make sure that there wasn't some kind of problem that needed to be addressed? That's the first question. The second question, when the CEO was not available, did anyone else try and meet with Ms. Moremi, or did your client try and make a different arrangement for her, or was it simply a no?
As it pleases the court, your justices, to answer your first question, the CEO, there was no need for the respondents to conduct any further tests, as the EIA itself is a test that is ensured by the government that the mine complies with all the environmental regulations. And secondly, as it pleases the court, counsels for the respondent contend that this court should consider that the CEOs have merit of responsibility, and the CEO's busy schedule cannot be interrupted by the residents while the mine already holds regular assurance meeting with the community. They should have raised their concerns during the meetings that the mine holds, and the CEO would have enlightened them about the proper channels to follow for addressing such concerns. It was justifiable for the CEO to dismiss the learners without hearing the merits of their complaints, as in this very esteemed constitutional court, a case was also dismissed on the grounds that the applicants did not follow proper procedures. This particularly would be the case of Pambili Fisheries Ltd and others versus the Ikurleni Metropolitan Municipality and others.
Does the fact that the CEO declined to meet with the applicants' learners have any connection at all in relation to the case that they have to prove before this court?
As it pleases the court, your justice, may you please rephrase the question?
Does the fact, or put it differently, whether the CEO met or did not meet with the learners, right? Could the case of the learners or the residents improve or be any better?
As it pleases the court, your justices, if the learners would have raised these concerns during the meetings, the CEO would have enlightened the applicants about the proper channels to follow when addressing concerns.
Ms. Silwana, why are the residents unhealthy?
As it pleases the court, your justices, it is stated in the facts of this case that the water of the Tiger River has suddenly turned grayish. However, it is not the mine that should be held liable for this, as there are other environmental external factors that could have contributed to this.
Thank you.
Do we know, or is it the applicant's case that if we are to exclude other external factors, the mining operations are the cause of the residents' ill health, or it's just speculation?
As it pleases the court, your justices, may you please rephrase your question?
Do we know, or is it the applicant's case that the main cause of the residents' complaint is the operations, or are the operations of the mine or other external factors?
As it pleases the court, it is other external factors that are affecting the ill health of the residents of Infantine.
And if it is the case of the mine that its operations are above board, in other words, no liability should be visited to them, does the fact that, notwithstanding its submission of annual reports, the reality of the situation is the community still suffers, and the teachers can confirm, and the employer itself, which is the mine, can see the number of absenteeism arising from ill health of its employees, not indicative of the fact that something somehow could be linked with its operations? Or is it a bridge too far?
As it pleases the court, Your Justice, counsels for the respondent contend that it is a page too far. It is the responsibility of the government to ensure that the citizens or the residents of Infantine are healthy.
Counsel, I want to ask you two interrelated questions. I would like your team of counsel hasn't really addressed any of the constitutional rights, and I want to ask you, please. The question I have, you say that the responsibility only lies with the state, but I want to ask you, Section 24 of the Constitution, which says everyone has the right to an environment that is not harmful to their health or well-being. Does the mine not also have some responsibility in terms of that right, or is it only the state that's bound by the right? And then secondly, I understood that the prayer that you're asking for, the relief, is to say that the mine's activities should not be stopped. Given the nature of the right that I've just read out to you, and that the fact that everybody has a right not to have to an environment that is not harmful, would it not have been appropriate for the mine to possibly say, let's suspend our operations until we have a proper investigation to work out to what extent the mine's activities are causing harm, given the fact that there's clear evidence that the community is being harmed? Thank you.
As it pleases the court, my Justice, may you please rephrase your question?
The first question, counsel, is I want you to talk to me about Section 24 of the rights, which talks about the rights to an environment. It says that everybody's entitled to a right that is an environment that's not harmful to their health or their well-being. Is it only the state who is obliged to make sure that that right is enforced, or does the mine not also have some kind of responsibility in terms of the right? Do the rights in the Bill of Rights only apply to the state, or do they also apply to private parties, the mine, for example, in this instance?
As it pleases the court, Your Justices, it is the responsibility of the departments to ensure that the rights under Section 24 are met for the residents of Infantine.
So you're saying that the mine has no responsibility and is not bound by this right as far as the Constitution is concerned?
As it pleases the court, my Justice, may I please consult with my co-counsel?
Please go ahead.
As it pleases the court, Your Justice, to answer your question, the rights are progressive and therefore are established over time. The state is bound, however, the mine can help.
Thank you, counsel. And just so, in light of your response there, I'd like you to answer the second part of my question, which was, would the responsible thing not be for the mine to, instead of saying we want to persist with carrying on our mining and we don't want the court to stop us mining, would the responsible thing not be to say, well, let's conduct an investigation and perhaps agree to suspend the mining operations until we get to the bottom of it?
As it pleases the court, Your Justices, it would be unfair for the mine to cease its operations while it is not to be held liable for the ill health of the Infantine residents, as they have complied with the environmental impact assessment.
Thank you, counsel.
Thank you, Councillor Sulwane. I heard you in your argument saying Ainfontein is 4 kilometers to 5 kilometers from the mine. And I understood you to say, in your view, that's not proximity to the operations of the mine. But is it not obvious that if there is mining operations in the radius of 4 kilometers, there is pollution, and the dust obviously will settle in the radius of 4 and 5 kilometers. As a result, it will affect the people who are living 4 to 5 kilometers from where the operation is taking place. What is your argument?
As it pleases the court, the Mineral and Petroleum Act requires that the minister should consider the impact of a proposed mining operation on the community when deciding whether to grant a mining permit. The Flames mine has been operating since 2008. Therefore, it was ensured by the government that the proximity would not cause harm. We can conclude from this that a relationship of neighborhood did not exist.
Just a follow-up. Wouldn't you concede that the department might have made a mistake to say it will not be affecting the community at Ainfontein by granting them the mining license?
As it pleases the court, Your Justices, there is no prima facie evidence or causal link that established that Flames Mine is indeed responsible for the ill health. Therefore, the state did not make a mistake. The proximity is well within the confines of the Mineral and Petroleum Resources Act of 2002, Section 16.
Thank you, Chief Justice.
Ms. Silwane, thank you very much for the presentation.
As it pleases the court, I will now take my stand.
Any rebuttal from the applicants?
May it please the court. Your Justice, we have heard the case about a mine that refers to the community that is essential to its existence as these people. Secondly, we have a mine that has made no effort to test for the alleged poison, despite the fact that the Water Services Act 108 of 1997 and the National Water Act 36 of 1998 says it is responsible. Please excuse me, Your Justice. Says that the mine must take all reasonable measures to prevent any such pollution from occurring, continuing, or recurring. They were told that the environment is now toxic, and they made no effort whatsoever to test this. Secondly, Your Justice, the Mineral and Petroleum Resources Development Act 28 of 2002 says that the holder of a mining right remains responsible for any environmental liability. Your Justice, a toxic environment is an environmental liability, and the mine is responsible for it. They made no effort to mitigate it whatsoever. In fact, they asserted that testing and checking that, okay, every year we are harming the environment this much. Rights are violated, but just because we are checking, it is fine. Your Justice, they also submitted that there were other possible causes. We satisfied the laws of damage. We satisfied the laws that are required in order to say that someone is liable. And because we satisfied that, the mine is legally liable. They submit that there may be other causes, but do not satisfy the laws of damage. Your Justice, the court cannot hold any other person or even the community itself in liability because those do not satisfy the law of damage. Now, Justice, move on to the third submission, which is that the test is unreliable because there is no certification. This is what the respondent asserted. Your Justice, but if you look at the same case, the mine says that they provide compliance reports. They also say that they conduct an environmental impact assessment. Where's the certification for that? Your Justice, that is also not certified. And if we cannot trust the test that was given, we cannot trust their compliance reports too. Your Justice, and then they say that the environmental impact assessment is enough. Your Justice, simply checking that you are harming the environment is not doing anything to stop it. Your Justice, and in this case, even if they say this, the rights of people are still being violated and people are being harmed. That cannot be ignored, especially because Section 11 outlines that the right to life, that everyone has the right to life first, and the table of non-derogable rights says that the right to life is entirely protected. If in this case you say that you are checking and you are still harming the right to life, it is entirely protected, and therefore you are still liable and still harming the community, and therefore the mine's actions are unconstitutional. But this does not end here, Your Justice. Your Justice, the respondent submitted that there is no liability at all because they say that there is an absence of a causal link. By definition, in the case of international shipping versus Bentley, it was established that the causal link is saying that there's a correlation between the mine's activities and the sickness of the people. We established that the mine mines lithium and the people are sick with lithium contamination. That's a causal link, Your Justice. With that, we rest our case.
Well, does the fact that the respondents, that is the mine, have placed themselves very far from the community, i.e. 4 to 5 kilometers, have any bearing at all on the element of causation?
Your Justice, when the mine is mining, smoke rises from its processing facilities, and smoke can travel for far distances. 4 to 5 kilometers is much too close, and there is a relationship of proximity. Thank you, Your Justice.
We'll have to adjourn. Yeah. Sorry? How long? Okay. Thank you. The court will adjourn thank you for the arguments from both sides. The court will adjourn for a few minutes to consider your persuasive and able arguments. We'll adjourn for 10 minutes and we'll resume at, the time is 12:14, maybe 12:30. Thank you.
right. Oh yeah, yeah. Move. You know what? It's too wide. Yeah? I can't afford it. It's too wide. Are you? Two of them. Three of them are being
thought we would come back within 10 minutes. It took us longer, and the reason being obvious that you have presented us with very good and persuasive arguments. And your presentations were excellent. All your presentations were excellent. So, in terms of the rules of the competition, we are required to make a decision as to who is the overall best speaker or oralist, and also the team. Those decisions were not reached easily. Amongst the 8 of us, we considered how you presented yourself. We did not look at the merits of the case, whether we agree with the conclusions or we disagree with the conclusions. But it is in the presentations. It is how you responded to questions. It is how you were able to think on your feet and give us a presentation. We are mindful of the fact that you were limited to the facts, and you could not veer outside the facts, because that would have been inappropriate. These are the pleadings. You had to confine yourself to the pleadings. Having said that, we were required to decide which is the team, who is the speaker. When we deliberated and decided as to who is the overall best speaker, the bench unanimously agreed that the overall speaker for the day is Mr. Mahono. But I must quickly indicate that one of the members of the panel would have chosen all of you as the speaker. So have that at the back of your mind. But he is the overall and enjoys our unanimous vote. Now, the next award relates to the overall team. Then again, here also, we did not look at the conclusion. We did not concern ourselves with the outcome. We also look at how the team prepared to deal with what was thrown at them and how they presented their case. The award for the overall team went to the respondents. The panel consists of 8 judges. 4 would have voted for the respondents, 3 for the applicants, 1 judge for both. So this is how it has turned out. If the judge who did not vote for either, or if it was a draw, then I would have had to make a casting vote. So it made my job quite easy because it's 4-3. So it's a split decision. So that simply says there was force in your arguments. You managed to split the bench into two, and this is excellent work. I think you should be really be proud of yourselves at the way in which you divided us. You'd probably want to know where I stand. I am for the respondent. If I were to divulge who stood for who, perhaps maybe you could go home and know that this was for me, this was for me. Mr. Sibanyoni was for the applicant. Judge Elmarie van der Schijf was for the respondent. Judge Wright would have voted for both of you. So he didn't use the right, both of you were both right, according to Judge Wright. Judge Yakub would have voted for the respondent. Mota judge would have also voted for the respondent. Jackie and would have voted for the applicant. That's how split we were. So at least we can go home knowing where we stand. And congratulations. I think, yeah, that's about it. We're done.
Thank you so much, Honorable Justice Matopo, for the feedback. Even we can also say, even us in the audience, we are unable to say with certainty who was going to win. So I can imagine how difficult it was for you. But thank you so much, Honorable Judges, for the great work and for the feedback and for handling the submissions quite well and assisting the students to understand even the rights in the Constitution and to continue to question them so that, and challenge them to think on their feet. Thank you very much. We are now going now to the prize-giving ceremony. So I'm going to request the judges' clerks to move this side so that the judges may then come down for the presentation of the prizes. And I'll invite the Department of Basic Education, the Department of Justice, and the South Africa Human Rights Commission to conduct the prize-giving ceremony for us. Maybe Joyce, if you are going to come forward so that we go into the prize-giving ceremony. Thank you so much. I'll ask the judges' clerks so that you vacate your place there and come this side. Thank you very much. The clerks can come this side.
If you could kindly ask.
So.
Rona, if you kindly ask justices to come this way, through here, this way. applicant team.
Thank you so much. And congratulations to the winners. Before I hand over to Joyce for the vote of thanks on behalf of the South Africa Human Rights Commission CEO, I would like to also just give a word of thanks to Dr. Elvis Fokala, who is our manager in the Children's Rights Unit at the Center for Human Rights, University of Pretoria, who worked very closely with Joyce and the team from the Department of Basic Education and Department of Justice to ensure that the Moot Court is a success. Dr. Fokala is there. I also want to thank Dr. David Ikpo, who is from our communications unit, who has been capturing the images. Thank you so much. Before we go and exercise our right to food, I want to hand over to Joyce for the vote of thanks. Thank you very much.
Thank you. I am giving this on behalf of our Chief Executive Officer, Mr. Vusmus Mkize. Unfortunately, it's his birthday today, and the family then phoned us to tell us that they had arranged a special surprise for him. Therefore, he could not join us today. On behalf of the National Schools Moot Court Program partners, we extend our deepest appreciation to each and every one of you who has made the 2023 edition a resounding success. The South African Human Rights Commission acknowledges the tireless efforts of the broad range of strategic stakeholders who are tirelessly contributing to building a culture of human rights through this program. To the deputy ministers who continue to champion this program, Dr. Regina Maule for the Department of Basic Education, the provincial MECs, provincial heads of department, provincial and district coordinators, and all the Department of Basic Education officials. To Mr. John Jeffrey, the Honorable John Jeffrey, and all the Department of Justice and Constitutional Development officials across the country. To the judiciary, the Office of the Chief Justice, and particularly the Constitutional Court justices, and all the esteemed justices today who adjudicated today's grand finale, led by Justice Matopo, Justice Yakub, Justice van der Schijf, Justice Misa, Justice Cassette, and Commissioner Sibanyoni. The legal fraternity, including all advocates, attorneys, magistrates, legal advisors, and law firms that have provided pro bono services in coaching and adjudicating the various phases of the program. The partners would like to acknowledge specifically Cliff Decker-Hofmeyr, where Ms. Jackie Cassette is from, and SM Patel Attorneys for sponsoring additional resources, as well as the Study Trust for the bursary opportunities that go with the program. All institutions of higher learning for assisting at the provincial level and the ESA phases. Specific mention, obviously, to our partner, University of Pretoria, the Center for Human Rights and the Child Rights Unit, and the Center for Child Law, for all the technical support provided and ensuring that the founding father's vision, Prof. Christoph Haynes' legacy continues to live on. All media houses who were here for publicizing the program, our schools, principals, educators, school governing bodies, parents, guardians, for guiding the learners. And most importantly, all the grade 9s and 11s, 9, 10, and 11s who participated in the program. Last but not least, the program implementers who work behind the scenes in coordinating the myriad of tasks required to achieve this key milestone. We thank you, Danki, Siyabonga, Enkosi, Riyaboha, Rorivua, Hatkenza. Thank you so much. That concludes my part from me. I hand back to the court orderly, our bailiff. lunch. Thank you everyone for attending lunch. It's served outside with packs. For those who have flights to catch, remember our discussion yesterday. Leave your bag in the trailer of the bus that is going to the airport. Everyone else, collect your bag, find your transport, and we head off. And we hope to see each other again this time next year. Thank you.
Well done. Oh, you're good with success.
Let's go speak to this doctor.
Jimmy, come on, don't think like that. Take more that would be